Good morning, Lloyd. Let me know if you still can't. You should be able to now.
Good morning. Now I can. Sounds like I got it in. Very good. Good morning, everyone.
Morning. Good morning, everybody. We've still got people coming in, so we'll get started in about 2 minutes. Appreciate you all being on time, and we will get started shortly. Good morning, everyone. We'll go ahead and get started this morning. I want to welcome you to our training on HUD required topics that need to be done in order to clear our ESG CV findings, and also ensure that we've got a fully functioning continuum of care with all of us reading from the same sheet of music, if you will. So with that, I welcome you. We've got an agenda today. I think Melissa will drop the agenda in the chat for the topics we're covering today. Today, we're going over policies that every agency needs to have, as well as things just to be aware of in those policies. Tomorrow, we will be going over forms, and the forms that we go over tomorrow will be related to forms that will be expected to be in use with contracts that will begin January 1st, 2024. So today is policies, tomorrow is forms, and thank you for joining. We are going to get started with Ruby Holmes going over our confidentiality policies, as that was one of the items that HUD flagged for us. And as we did our monitorings, a lot of agencies did not have confidentiality policies in client files, and we do need to make sure that clients are aware of our confidentiality policies. So with that, I will hand it over to Ruby. Thank you, Ruby.
Good morning, everyone. I'm Ruby Holmes with the City of Durham Community Development Team, the Homeless System Analyst. I'll be presenting on the confidentiality policy. All right, so first up, each organization should have their own confidentiality policy that has the procedures, processes that you use to keep your client's information secure. That information should be kept in a secure location, either in a locked cabinet or in a secure electronic format. The information also includes the protected personal identifying information, which includes their full legal name, their date of birth, social security number, and disabling conditions. When we discuss confidentiality, you want to make sure that you refrain from using those identifying information in public areas, sort of in conversation where other individuals could hear it, and also refrain from using the PII in email communication. So you want to make sure that you're using the client's HMIS number instead. I would also refer you to NCCEH's privacy and security training that goes into more detail around using confidential information as well. And then there is a confidentiality agreement that is between the provider and the client. You want to make sure that you provide the participant a copy of your confidentiality procedures and the processes that you use to protect their information. And then make sure that the participant reviews the information, and they can also sign the acknowledgement of your policies. And then you want to keep a copy of that signed acknowledgement in the participant's file. So any questions about the confidentiality policy? And my team, please add in anything if you have anything else to add.
Any questions on confidentiality before we move to the next topic? Next topic, we will hand over to Lloyd Schmeidler for update on homeless eligibility, as our entire system is designed to assist folks who are experiencing homelessness. And in order to do so, we must document that. And thank you, Princess. If you've got questions, put them in the chat or raise your hand, and Melissa can work to make sure we get those questions answered. So Lloyd, do you want to give it a second while we see if there's questions that come up in the chat? If you have questions as we go, put them in the chat. We'll respond, and we can keep moving so that we can get you out of here on time. These presentations will be posted and the training will be posted. A lot of the policies that we talk about today are not actual policies that the city of Durham is writing, but these are things that each agency needs to have in their own organizational policies and procedures. So it's sort of working with your own organizations to ensure you've got a confidentiality policy. So as Ruby said in confidentiality, how are files stored? Where are files stored? Where is this identification kept? Where and how do we inform clients of how we keep their information confidential? So a lot of these are related to organizational documents that must be held on site. If you need help and some guidance getting pointed to stuff, we can assist you and refer you to the HUD Exchange for some samples, or reach out to some of the peers on the call who may have some of these documents already. Other questions? Go ahead, Lloyd.
All right, thank you, Colin. Good morning, everyone. Lloyd Schmeidler, Senior Community Development Analyst with the Homelessness Team. This next section is on documenting homelessness. Let me see if I can get my screen to advance. There we go. So we're going to assume some familiarity with the 4 categories of homelessness in HUD's definition of homelessness: literal homelessness, imminent risk of homelessness, homeless under other federal statutes, and attempting to flee domestic violence. Recently, HUD also added, I think, human trafficking to the 4th definition, so we can be aware that the term domestic violence covers a number of situations in which people are fleeing to escape abuse, intimate partner violence, human trafficking, etc. So in terms of documenting literal homelessness, hopefully much of this presentation is a review for many of you, but for those of you that it's new, certainly HUD has good guidance on this. Written observation by the outreach worker documents literal homelessness. Written referral by another housing or service provider documents literal homelessness. Self-certification by the individual or head of household seeking assistance, stating that they were unsheltered or in shelter, is also acceptable for street outreach or emergency shelter projects. However, third-party documentation is required for rapid rehousing and permanent supportive housing projects. However, there are some relaxation for rapid rehousing and permanent supportive housing projects in which they can accept a limited number of months or a limited number of participants self-certifying their homelessness, and we can talk more about that as need be in the Q&A. Also, part of the Category 1 definition is people who are exiting an institution where they had resided for 90 days or less, and they had been literally homeless prior to entering the institution. So, for example, somebody is unsheltered who was incarcerated in the Durham County detention center or jail for less than 90 days and had been homeless prior to going to jail, can also be considered literally homeless. Again, documentation of that includes written observation, written referral, or self-certification, and discharge paperwork from the institution, or written or referral from the institution, or the written record of the intake worker's due diligence to obtain the above evidence and certificate, again, self-certification by the individual that they had exited the institution. Imminent risk of homelessness Documentation of that could be a court order resulting from an eviction action, could be for people leaving a hotel or motel, evidence that they lack the financial resources to continue to stay there, if they had been paying for the hotel stay themselves, or a documented and verified oral statement by the people seeking homeless assistance, and certification that no subsequent residence has been identified for them, in a self-certification or other written documentation that the individual or family lacks the financial resources and support necessary to obtain permanent housing. Category 3, homeless under other federal statutes, this category is not being used to provide homeless assistance to people in Durham, primarily because we have not run out of people meeting category 1, category 2, or category 4 definitions of homelessness. So as long as we're continuing to encounter and have households in those other 3 definitions, we're not using category 3, which is homeless under other 4 statutes. So we're not going to concern ourselves with documenting category 3 homelessness in this presentation. We are encountering, as some of you know, increasing numbers of people fleeing or attempting to flee domestic violence and seeking homeless assistance. For any victim service providers on the call, documenting that need for assistance can simply be an oral statement by the head of household or the individual seeking assistance, in which they state that they're fleeing domestic violence, that they have no subsequent residence identified for themselves, and they lack the resources to obtain other permanent housing. This kind of statement could be documented by a self-certification written statement, or a certification by the intake worker that they received this certification orally from the household or the head of household or the individual on such and such a date. For a broader category of non-victim service providers, which probably would include most of the people on the training today, a similar oral statement could be documented by self-certification or certification by the intake worker, and where the safety of the individual is not jeopardized, the oral statement must be verified. Certainly if a household is perhaps hesitant to provide this kind of oral statement to a non-victim service provider, the intake worker can verify that in a signed statement that they received that, or that they are verifying the household's homelessness according to category 4 definition. The verification also, again, should include that no subsequent residence has been identified, and that the household lacks the financial resources and support networks needed to obtain other permanent housing. So these are all kind of part of the definition. It's not simply that households are fleeing, households or individuals are fleeing domestic violence, but that they also have not been able to identify a safe residence to move to as they're escaping or fleeing, and that they don't have the financial resources to obtain other permanent housing. Moving into a few slides about the standards for documentation. Again, as we talked about at the top of this training, agencies should adopt standards in their policies and procedures, and those standards should include strategies for addressing the requirements around sufficient records to verify homelessness. Agencies should have clear guidance that they can train staff in as new employees come on board, and train the employees in what is needed to verify homelessness, at least in the 3 categories of homelessness that we are reviewing in this presentation. So general examples include that the record clearly identifies the entity providing the verification. We clearly identify the individual or head of household that the verification pertains to. Sometimes that can be self-evident, but sometimes we perhaps are not as clear as we could be in just identifying, particularly in a non-victim service provider setting, the HMIS number, for example, of the household that the verification pertains to, and then clearly stating the condition or criteria pertinent to the homeless definition. So that's clearly stating the category of homelessness that the household is homeless under. Could be an important standard to include in your policies and procedures. Third-party sources, HUD has a priority for documentation of homelessness. The highest priority is third-party sources. Again, self-certification is acceptable for emergency shelters. It is generally not sufficient for rapid rehousing or permanent supportive housing or other permanent housing that's dedicated for use by people experiencing homelessness. So a third-party source is an official communication on letterhead or perhaps a statement template. Should be signed and dated. A general statement that is not signed and dated that says, this person or household is homeless, that is not sufficient as it should be signed and dated. And then additional standards could depend on the purpose of the third-party source document. So examples include evictions, statements about wages, housing history, living situation, length of stay, economic hardship. Sometimes information in the HMIS documenting homelessness can be cited as a third-party source. If, for example, the HMIS documentation shows entry and exit history from an emergency shelter and a rapid rehousing project is using that documentation as third-party documentation of homelessness. Also, a third-party source is recorded oral statements. These oral statements can be accepted by an intake or staff or caseworker. Should be documented of the third party providing the verification, signed and dated by the intake staff worker as true and complete. And I've placed in this presentation the words true and complete in quotation marks to encourage intake workers to include that kind of language in a statement. So for example, a street outreach worker could provide an oral statement to a shelter to say that they are verifying that this particular household or person was encountered as unsheltered in Durham, and they considered this to be a true and complete verification of the household homelessness. But also recommends that projects have HUD recommends that projects and agencies have a standardized form for programs, so we're passing on this recommendation to have clearly labeled sections, including relevant details and certifications. We'll talk further about forms tomorrow. Recorded intake staff observations can also serve as verifications of homelessness. staff notes, and assessments, again, should be signed and dated as true and complete in the client record, and they may be used for documenting homelessness. Intake staff observations are not appropriate for documenting income, and we'll talk about that in a later presentation. Sometimes staff make every effort to verify homelessness, but they're not able to completely verify homelessness. And in those kind of situations, HUD does allow for what's called due diligence, in which the staff seek to verify over a period of weeks that they have sought to obtain third-party verification of homelessness. And those due diligence documentation could include, for example, phone logs, copies of email correspondence, copies of perhaps certified letters that the agency may have sent to an institution, for example, to get verification of an institutional stay, or other kinds of efforts to obtain that third-party verification. The details of the outcomes, including the obstacles, for example, the documentation might say our agency sent emails on these dates. You can include a copy of the dates, and after 2 weeks we didn't receive any response. We sent a certified letter on this date, also did not receive a response to that within a period of time, but that we do consider based on the self-certification of the individual and our understanding, we can continue to believe that the client met the homeless definition, and the staff then sign and date that kind of documentation and consider it to be a true and complete record of the efforts to obtain documentation. And that is all I have on documenting homelessness. I think we're still well within time, so we can entertain or discuss any questions that may have come up in the chat. Colin, are you managing the chat?
Yes, sir. I haven't seen any questions come up in the chat as of yet.
Again, hopefully many people on the call, if not everybody, is fairly familiar with the guidance on documenting homelessness. If there are any questions about it, HUD does have, again, good guidance on the HUD Exchange. A lot of this information was taken from a presentation that HUD made, a webinar HUD several years ago on this on the importance of documenting. Again, documentation. Emergency shelters are not required to get third-party documentation if it's available. Great. If not, people can self-certify to enter into shelter. But verifying homelessness does require efforts for rapid rehousing and permanent supportive housing projects. I think our street outreach projects can document unsheltered homelessness. People in unsheltered situations have been involved with a street outreach project, and the street outreach project has been providing assistance to the unsheltered household for a period of time. They can document that period of time, and as well, permanent supportive housing projects increasingly can use the documentation in the HMIS as third-party documentation. Perhaps the most challenging documentation could be getting documentation from an institution that a jail or a mental health institution or a hospital, something like that, that would verify the household's time in shelter. I'm going to stop sharing then. If there's no further questions, we perhaps can be ahead of schedule and move on to the next presentation.
Thank you, Lloyd. I don't see any other questions coming up, but we'll give it another minute. There's no other questions. I will hand it back over to Ms. Holmes, Ruby Holmes, to talk about rental assistance agreements.
Good morning again. We'll discuss rental assistance agreements. It's really short, just to discuss some of the aspects of a rental assistance agreement. So it is a separate document between the tenant, the provider, and the landlord. There is a template available on North Carolina ESG rental assistance template is available, number 4.0. Just to make you aware that it is not a lease, so it is separate from the lease documentation. This is an agreement that is between the tenant, the provider, and the landlord, and that lays out the responsibilities for each party. When you discuss the rental assistance agreement with the participant, you want to make sure that you go over the lead-based paint hazards and the fair housing requirements. I believe the current version of the rental assistance agreement that is available online also has a VAWA 2023 addendum to it, which outlines some of the VAWA policies as well. And so once you have the agreement, the tenant, provider, and landlord, and I'm stressing all three because it's not a rental agreement unless all three sign that agreement. And you want to keep a signed copy of that agreement in the participant's file. Any questions about the rental assistance agreement between those three parties? That's all I have, and thank you for that, Lloyd.
Louis, since we have some time, could you give some examples of what a rental assistance agreement, what the tenant and the agency and the landlord might agree to in a rental assistance agreement? A few examples.
Sure. So here's a copy of the template that is available online. And you will have that the agreements between the contractor, which would be the provider, and the landlord, and also list, the unit name, some of the information about the tenant themselves and what they are, the assistance that they will provide, the provider will provide to the tenant. Some of the information would include how much the security deposit will be, how much the rental assistance payment might be, the time frame that they will be providing rental assistance as well, and then what that total might be that would be provided to the landlord, stating what dates the due date for the payment would be, any late payment penalties as well, if any of that will be paid for by the provider. And it just lays out what would happen in the event that the tenant does not pay their portion for some reason. It also lays out who would be paying utilities, maintenance, and other things like that, and who is responsible for the upkeep. You also have some information about lead-based paint here, as well as some of the obligations that the landlord may have as far as accepting rental assistance payments, and when they need to notify the provider as well, if the tenant vacates the unit. The information about monthly payments and how requested documentation would be accepted in order to be paid by the provider. And then also any information about termination of the assistance, termination of the agreement, or termination of the lease as well. There's also information about fair housing requirements here that you can discuss with the participant. And then this is a legally binding document, so that's why we want to make sure that we get the landlord, the provider, and the tenant to sign it. And it's not just an email, it's not just a document that's provided, it is signed by all three parties. And then you have space for all of the parties to sign. And on this version of this document, there is a lease addendum for VAWA to be included. Some information about why what VAWA is, why they're adding why there are VAWA protections and things like that. So any questions about this document?
Ruby, we didn't really talk about it in our preparation for today, but the question comes to mind, particularly in that it relates to perhaps my next presentation on reevaluations, and that is question of our written standards for Durham call about require reevaluations every 3 months. This might be directed towards Colin. Do we need a revision of the rental assistance agreement if the amount of assistance being provided by the rapid rehousing or PSH project changes every 3 months? How do we expect projects to handle that when the amount of assistance provided changes and we expect the tenant to pay more income?
That's a great question, Lloyd. And whenever your rental assistance agreement should be, as I like to say, highly specifically vague, in that the rental assistance agreement can be for the first month, the first 3 months of how much rental assistance is being provided by the referring agency. And the rental assistance agreement can say the agency will communicate to the landlord on X date monthly if and when that number that's in the original agreement would change. So let's say agency A is going to pay $1,000 in the first 3 months, and they would put in the assistance agreement that no later than the 15th of month number 3, they will communicate to the landlord if there will be $1,000 coming from the agency or more money or less than, so that the landlord knows how much to expect from the participant in the program, as well as how much to expect from the agency. So you don't necessarily need to go back and rewrite the housing assistance agreement. You just need to follow up and make sure you have documentation of notifying the landlord what the agency's intention is or what is changing on that month-to-month basis. So you would just kind of add it as an addendum, and it's more of the communication and the follow-up, because the landlord agreed at the beginning to receive that information from the homeless service provider. Does that answer your question?
Yep. Nicole has a question in the chat. The coordinated entry program, when we provide move-in assistance, do we need to use the rental assistance agreement, or is this rental assistance agreement just for rapid rehousing and PSH projects?
Nicole, that is a great question. And I don't believe it's in the contract. However, it would be best practice to have one where you would make sure that the landlord is clear that this is a one-time assistance. You don't want them thinking they can come back and say, hey, this tenant isn't paying their rent, and I know you gave me some money. and you need to give me some more. So I would say, go ahead and use it. It helps keep things nice and clean.
Sally Wilson asks whether the rental assistance agreement is added as a written addendum signed by all parties.
It is an addendum, and it's not an addendum to the lease. It's a separate standalone document. So the lease is the lease. This is a separate agreement that all parties enter into with a clear understanding of who has what role to do what and when. So it's not part of the lease. It's a separate standalone document. I hope that answers the question.
Yep, very good. Thank you. And Beverly asks, I'd like to know if we could use this agreement for rooming houses as well.
You would use this for everything. You would use this for every lease where there are three parties involved. So anytime you're leasing something, the tenant's name is on something and the organization's putting money into it, providing supportive services. So yes, if it's tied to a rooming house and there's money going in there, there needs to be a housing, having the rental assistance agreement. And in an ideal world, you can't update these every 3 months if that's easier for you. If the original rental assistance agreement is changing every 3 months, then it's probably wise to go and update it every 3 months, unless you state otherwise.
Questions? Thanks for the questions. Makes for a better training when people are asking good questions. So let's see. Nicole goes on to ask, would we use the rental assistance agreement for other housing assistance outside of rapid rehousing?
Yes, rental assistance agreements are required for homelessness prevention, for rapid rehousing, and it's probably a wise idea to also have it for PSH projects where you have a PSH project, for instance, would probably update their rental assistance agreement annually, as things don't change as frequently as with a rapid rehousing or a homelessness prevention project. And as we stated, anytime an agency is putting money into a project as a third-party payee and providing some level of supportive services, even if it's just writing that check, it should be clearly documented so the landlord knows exactly what the agency is doing, the tenant knows exactly what the agency is doing, and the agency is clear on what their role is in this, so nobody can come back and say, oh, well, you gave me money and I thought this and I thought this. The rental assistance agreement is there to clearly delineate who has what responsibilities for what period of time, and it gives you the cover you need should somebody come back and say, well, you told me this. It's like, no, here's what we agreed to. It clearly states we're helping for 3 months and that's it. Or it clearly states we're helping for 6 months and that's it. So, make sure you stay on top of these. These are the things that come back and bite you really quickly when things go south with landlords, because they come back like, well, I got this note promising that people would do this and it's open-ended, or I never got anything in writing. So I assumed the agency would cover this in perpetuity, where statutorily rapid rehousing and prevention funds cannot be used for more than 24 months.
Paul, Lamb asked, do we still need approval letter document besides the rental assistance agreement?
So
Yeah, I'm not sure what approval letter Nicole Lamb may be referencing.
yeah, I don't know what the approval letter is. The welcome letter.
Welcome letter when the client is approved.
So you would probably use your rental assistance agreement in lieu of a welcome letter, or in addition to, but we can talk about that. We can set up a time for technical assistance on that, Nicole. Without seeing the document, I can't comment one way or another which way is the right way. And Nicole Bagley, if you're using private funds, I would say it's probably better to go ahead and put it in there if you're using private funds, especially if those private funds are being counted towards match. And from an organizational standpoint, it's usually easy. While it's a pain to have to do an extra document, it's often more of a pain for people to remember which pot of money am I pulling from and which pot of money needs this, which pot of money needs that. And oftentimes, by the time everything gets sorted out, oftentimes the funding sources shift. So it's probably better to have everything follow the same pattern. So even if the money that you thought was coming out of private funds ends up on the books getting charged to an ESG grant, you've got all the backup documentation. So the general rule with policies and procedures is if there are multiple policies and procedures, follow the most restrictive because you'll always be fine.
Just add to that, Colin, that if you're using private funds for short-term assistance, it's still good to have the rental assistance agreement documentation again, so that if there's any misunderstandings, you have some written documents to show this is what everybody agreed to, right? And can just avoid confusion. Good discussion. Thanks everybody for the questions. Ruby, Colin, anything else to add?
I don't have anything else to add. Thank you.
Where Beverly asked, where can we obtain this agreement? Again, we'll have a rental assistance agreement form referenced tomorrow in the discussion on forums, and it is also available at the North Carolina ESG website at the State Department of Health and Human Services. Search for HHS. We ready to move on?
We are. I believe it's back to you, Lloyd.
All right. Let me see. Got my this.
We will be going into reevaluations, and this is sort of the next logical step. You have your rental assistance agreement, and HUD does require regular reevaluations of participants in the program. So this will talk you through the next steps and when those rental assistance agreements would need to be updated and ensuring tenants and landlords are aware of things. So go ahead, Lloyd.
That. Let me get to the right presentation. Now I think we're on the right show. All right. The reevaluations. Reevaluations concerns especially rapid rehousing projects, as well as permanent supportive housing projects, ESG and COC projects that are providing rapid rehousing assistance, must conduct regular reevaluations at least every 3 months according to the Durham COC standards of participants receiving rapid rehousing assistance. PSH projects are not directly referenced here, but there is an annual assessment done in PSH projects every year within 30 days before or after the household's entrance into the PSH project. An annual assessment should be completed. The reasons for reevaluations are to document the continued eligibility for assistance, right? We want to demonstrate clearly that the household continues to need the assistance of the particular project. And so we need to be able to document that. And we're documenting not only the amount of assistance needed, but that the household has a continued lack of resources and support networks. that there's a continued need for assistance to maintain permanent housing stability, and we're documenting that the participant household's annual income must be less than or equal to 30% of the area median income. I think one of the, I know there's a lot of work for case managers to do in working with households as they are transitioning from homelessness into permanent housing. Part of the work of those housing stability plans and the housing plans should be looking at not only what are the efforts to help households and perhaps improve their income so that over time they can, in a rapid rehousing project in particular, assume more responsibility for paying the rent. And so using progressive engagement approaches to do that, but also focusing on how can we help a household get more connected to other support networks, whether it is perhaps getting into some kind of group programs. There are a variety of support programs in the community. Sometimes, the city's Parks and Recs department has a variety of programs. The Arts Council has programs. There's a lot of free and low cost, really, programs that can help people develop more support networks. If they are interested, there's religious congregations that perhaps, particularly as people are relocating into another part of town, if they are people of faith, they may want to get connected to or reconnected to a religious congregation, and the case managers can help reconnect them to those programs at Durham Tech or at even if they are not formally served by the Durham Crisis Response Center in terms of housing assistance. DCRC has a variety of support programs for households that are fleeing domestic violence, and those kind of programs can be of tremendous support to people, as well as various programs of Alliance Health, as well as the programs at Durham. Durham Social Services has a variety of support programs that could be beneficial for people. So part of the work of a case manager is really kind of casting a net pretty widely as to the kind of programs that can be of support to people. And if people I was recently reminded of the Durham Network of Care, which is an online resource. If you're not familiar with the online resources at the Durham Network of Care, I really encourage you to Google that, and you'll find a wealth of information that I think is being maintained pretty actively and stays current to explore support networks and resources that people can be connected to. Obviously, as always, the households need to want to do that. It needs to be voluntary. Projects cannot require people to participate in any of these supportive opportunities, but case manager, based on the household's needs and their desires, should be more knowledgeable about the resources that can help a household than the household is. So be aware of that. So documenting the lack of resources and the needs can be self-certification supported by other documentation when that's practical. So examples can be a termination notice of termination for utilities, being terminated. Unemployment compensation statements can document how much income a household is receiving. Bank statements can also document how much income is coming into a household on a regular basis, as well as bills showing arrears that need to be paid can document the household's overall need. A lot of this presentation talks about income that should be considered when households are being reevaluated. Examples of acceptable documentation, again, the best source is third-party source documents, which are considered, again, source documents are documents that are not directly related to documented continuing eligibility for the project. Banks, things like pay statements that are documentation of the pay the household is receiving would be considered a source document. Third-party written documents would be a statement by an employer saying specifically to the project that yes, this person is currently employed in this organization. Third-party oral might be documentation of a conversation that the intake worker or the case manager had with the employer, and you receive an oral statement over the phone, and you document that you received it on such and such a date, and accurately recorded that. And then again, a self-declaration could be a written statement by the head of household, or an oral statement that is recorded as having been received by the case manager. When we are particularly focusing on documenting the continued need for support by the project, as well as considering whether the household continues to be at 30% or less of area median income. These are the income categories that need to be considered. Now, probably in most situations, only one or two or three of these are going to be applicable to any one household, but it is good for case managers to be aware that these are the income areas that should be reviewed with the head of household or the individual. So examples of acceptable documentation, again, earned income statement. We're talking about each of the income sources. We'll go down each one to look at acceptable documentation. So for earned income, wages and salary, good third-party source document is a payment statement, or perhaps a quarterly statement of some kind from the employer or that source of income. If we encounter people that are self-employed, perhaps they at one time did not have any income, but they are starting a small business, have a colleague from previous employment who went out on disability, and she, to keep herself occupied, she started a small business of designing and making Christmas ornaments and other ornaments, plaques, greeting cards, etc., that she sells online. And so she, does have some business income, so that if she were homeless, gratefully she's not, she could, that income could be considered self-employment or business income. And the project could use a financial statement, again, perhaps a bank statement or perhaps a financial statement that the person in the household is maintaining in QuickBooks or in other financial accounting methods. Just a hard copy. For interest and dividend income, typically people are receiving interest or dividend income statements at least quarterly, sometimes monthly. So those kind of statements would be verification of interest and dividend income that might be coming to the household. Perhaps they have a small account at the local credit union or at the local bank, and they have some savings there. And those income and dividend statements, that income should be considered. Pension and retirement income, if people have, we know that we are seeing increasing numbers or an increasing percentages of people experiencing homelessness are older, and so could be likely that we'll see increasing numbers of people that one of their income sources is retirement income, whether it's a pension or other statement. And so to be asking about if they are receiving pensions or other retirement income, ask for statements about that. Armed forces income, probably not likely, although we do, those of you that are working with veterans or recent veterans may have armed forces income or a statement of income from a government official or agency. It's likely that many of the people that are in projects, particularly for permanent supportive housing, may have supplemental security income or supplemental security disability insurance income. And so those kind of statements would verify that kind of income source. Public assistance, temporary assistance for needy families. I think in North Carolina it's called Work First. People are receiving income notices and benefit statements from either the county or the state as to what their current assistance levels are, and those statements would verify that assistance. We may have some households that are receiving child support. Generally, if people are taking care of minor children and are not receiving child support, certainly, again, part of the work of a case manager could be to explore opportunities to obtain child support from the parent who is not with the household. Court orders of that can be documentation of that, as well as recent payment statements. Self-certification, written or a case manager's written verification of an oral certification would suffice in situations where the household says there was no income reported, as much as possible. Again, unless the client is consistently saying they don't have a bank account and the case manager has not helped them set up a bank account, the self-certification would need to be maintained every 3 months, and then part of the work of the case manager, right, would be to look at, okay, what are we going to do over the next 3 months for this household in a rapid rehousing project to begin to obtain income for the household so that they can begin paying a portion of the rent and over a period of 3 to 24 months become self-sufficient in the rapid rehousing unit. Briefly, just one slide on income exclusions. These are that income that may be coming to the household that is not to be considered part of the calculation as to whether or not the household meets the 30% AMI threshold. So, for example, if a household has a 16 or 17-year-old that is working part-time, perhaps to, perhaps some of it is used to support the family, but the income of minor children is not part of the 30% AMI calculation, even if it's being used by the family. Some children might be working to, save for college or to supplement what the family can provide for their schooling or whatever. But in any case, with few exceptions, the income of children is not considered. Child support would be considered if it's coming from a parent who is not in the household. Inheritance and insurance income. Family has a car and they have an accident and they get a insurance payment from their insurance company. That is not part of their ordinary income. If a relative dies and they're left in inheritance, the income is not considered part of the calculation as well. Medical expense reimbursements are not included. Income of any live-in aides. Doubt that we have anyone in housing that has a live-in aid, but again, that income, if there were situations like that, would not be considered. Statements concerning disability, can investigate those with more, and if you need, again, technical assistance on some of those things, our department can provide more guidance. Student financial aid is not part of that, so that if, for example, a parent is studying at Durham Tech or at NC Central or even at Duke, and they are receiving financial aid of one kind or another, that would not be considered part of their annual income calculation. And then armed forces hospital prior pay that maybe a veteran received after they exited the armed forces would not be included. Want to just briefly included this slide primarily because it was in the slideshow that HUD that I used from HUD to guide preparation of this presentation, but HUD has clear guidance in the income calculator. If people are not familiar with HUD's income calculator, this I think is an active link. Yep, it takes you to this page. Encourage people to, if you're not familiar with it, perhaps the address is hudexchange.info/income calculator/. And if your project is not already using the income calculator, HUD does make it pretty easy for you to use that calculator, and that can be a helpful resource. Actual income from assets. Sometimes people assets would be things like if people own a car, how do you consider that in their income? And so actual income from assets is, or if there's like if they have, for example, a $2,000 in their savings account, those $2,000 are an asset. How do you consider that for the income calculation, right? So HUD clarifies in that in dealing with many assets, you're not looking at the value of the asset as much as the income that asset provides to the household on a regular basis. And so there's clear guidance at the income calculator on what to include and what to exclude when you're considering any assets that a household might have. So again, in documenting income, you want to calculate the income, you want to analyze or annualize, I think that's the correct pronunciation, annualize the hourly, weekly, or monthly payment information as appropriate. That is to say, if they're receiving, generally a pay statement is going to be weekly or perhaps bi-weekly or monthly. And so you're going to want to multiply a monthly payment information by 12 months to get a sense for what their annual income is. And then you're going to want to compare that against the area median income. I think we recently distributed HUD's recent adjustments to area median income. HUD adjusts the, not sure which government agency it might be, the census or HUD that distributes area median income. We know HUD distributes information about fair market rents. Area median income may be calculated by the Census Bureau, but also computed by in any case, a department of the federal government and released. And that is fairly accessible online as well. And then you want to keep documentation in your case files of the calculations, and again, use the income calculator for ease of calculation. I think it's pretty helpful. That's all I have on that. Any questions? Question, does this include households that receive SSI for a disabled child under 18? Let's see, it's a great question. Go back to that income calculator and see if we can quickly find some information about that. I'm going to get back to you, Rebecca, on that question. And we will send it out to you.
All right. Any other questions from anyone on reevaluations? All right, if not, we'll jump into the next topic, which is terminations. Share my screen here for a second. All right, this is the termination policy, and a lot of this comes straight from 24 CFR, which is the Code of Federal Regulations that govern ESG funds. And these are specifically about terminations from ESG funded projects and can be applied elsewhere in our system. So we're going to start off with what is termination? Generally speaking, this is when program participants violate program requirements. And the recipient or subrecipients in this case would be the agencies, the nonprofits. If you're a recipient, you would be a recipient if you received state ESG funds directly to, no, you'd still be a subrecipient. So all of you on this call are subrecipients of ESG funds. There are no direct recipients from HUD of ESG funds. COC funds, you would be a recipient, otherwise known as a grantee for continuum of care funds. So services can be terminated as long as you follow the formal process that the agency has in place and includes and recognizes the rights of the individuals who are in the program. You must use judgment and look at all the extenuating circumstances to determine if violations rise to the level of termination. And if it rises to the level of termination, it should only be used for the most severe cases. And this is HUD's language specifically, I paraphrased. So make sure that termination is really supposed to be used in last resort. When we're terminating rental assistance or having to terminate somebody who is in a rental assistance program, we're looking at really making sure that we follow the formal process. That formal process that the agency has to have documented must provide written notice to the program participant that clearly states why they are being terminated from the program. There needs to be a review of the decision with the participant where they have the opportunity to present their version of the story to someone other than the person who made or approved the termination decision. So make sure you've got somebody else in there that can be sort of your neutral observer and sort of weigh both sides of the story before things are finalized. After you have that hearing, for lack of a better term, then you need to provide written notice as quickly as possible to the program participant of the final decision. Keep in mind, termination does not equal suspension or a ban from a program. So just because somebody got terminated from rapid rehousing for lease violations does not mean that they cannot receive assistance at a later date, assuming they meet all the other HUD eligibility guidelines. So just something to keep in mind, termination is not the same as a suspension or a ban from a program. Now, when we're talking about how and what do we have to have in place to terminate a participant, you have to have given a copy of the rules and the expectations to the participant. That document also needs to include what items in this set of rules will or could result in termination. The participant also must be given a list of or an explanation of what is the termination process that the agency uses, i.e., does the agency give 2 verbal warnings and then it becomes a written warning, and then there's 3 written warnings before it turns to a termination. And then the agency has to have a procedure on how do they document verbal warnings, written warnings, and what is the process for the official termination of the participant from that particular program. All of those must be given to the tenant or the participant in the program prior to the tenant or participant enrolling in the program or at intake. There needs to be documentation that all of those things were explained to the program participant. It wasn't just here's a bunch of paper, read it when you're bored and sign here. It's document that there is a process to ensure that all participants understand what they're being held accountable to. So they have the right to say, I can't do this, or I don't want to do this. This is where a lot of our grievances come in with terminations. Our people claim they didn't know that rule was there, but there's a piece of paper with their signature on it and they didn't understand it. The agency must document that the rules and termination process, like I just said, were given to the participant ahead of time. The agency must follow your termination process and have documentation of the violations that are resulting in the participant being terminated. So if there's no documentation that, Johnny did X, Y, and Z, but you're terminating him, there's no paper trail. If that grievance comes to the continuum of care, the person was terminated, you're going to have to come provide documentation. If you don't, you're going to have to reverse that decision. So everything must be documented, and as termination is really the last resort. The participant, make sure that in your process, the participant has the option and the right to provide documentation that they did actually do what they were supposed to be doing, and make sure you've got somebody who can hear that and before the final decision is made. The participant also has a right to appeal all of those, any terminations. They can follow the agency's grievance policy to appeal, or go through the COC's grievance policy. And tenants or participants should follow the agency's grievance or appeals process prior to seeking relief from the continuum of care's grievance policy. So make sure that you encourage participants in your programs to use the internal grievance policies that your agencies have, as they're there for a reason. HUD does not give any specific criteria related to things that participants should be terminated from in street outreach or emergency shelter, other than termination should be a last resort. We at the city, as the lead agency in our continuum of care, have said health or safety issues are the only reasons somebody should be terminated, as that's what is in line with the housing first model. Is we really want to be housing first and housing focused, and the only time people shouldn't be able to receive assistance in our system are related to egregious health and safety issues, as we want everybody to be healthy and safe. Rapid rehousing and homeless prevention terminations or exits. So a lot of people get confused, termination or exit. When a participant no longer meets HUD's eligibility requirements, the person is exited from the program. So you don't get terminated because you are making 35% of the area median income at your evaluation for rapid rehousing. You're exited because you no longer meet HUD's statutory eligibility requirements. The same would be true at 24 months. Somebody had been receiving rental assistance and rapid rehousing. Well, they're not going to be terminated from the program for that. They're exited from the program because they are no longer eligible for financial assistance for month 25. When somebody is exited from the program, you do need to include written notice to the participant of why they are being exited from the program, with an exit date and the date that any assistance will end. Sometimes the exit date may be one day, but the assistance will cover them for, they might be exited on October 1st, but the rent for October had already been paid, for instance. Landlords also need to be made aware of when participants are exited from the program. So this goes back to what we talked about earlier with the rental assistance agreements. Landlords are a party of this in rapid rehousing and prevention. So when a participant is no longer eligible for services, the landlord needs to be made aware of that in writing, not just a phone call, but put it in writing, and make sure, if at all possible, you get in writing back from the landlord that they are aware of the termination. And if in an ideal world, you would have the tenant, the participant, and the landlord and the agency sign off on a new rental assistance agreement, clarifying that this is no longer in effect. Now, remember, termination from rapid rehousing and prevention programs is a last resort and should only be used when the participant violates program requirements or conditions of occupancy. So when those rise to the level of unable to be fixed, the participant is not willing to do their part of what needs to be done to remain in the program, or has lease violations that they have been unwilling or unable to fix, those are times where termination can be used with the rapid rehousing or prevention projects. Just make sure that you do everything and you document everything you have done to show that termination was your last resort. Terminations, letters of termination, must be kept in the client file as well. So please make sure you have those. as those are things that we look for when we're coming in and doing evaluations and monitoring programs. We do want to make sure that if people are exited or terminated, there are letters to the tenants about those exiting events. Any questions? Any questions? All right. There's no questions. Anthony, if you are ready, sir, to go over grievances, if you're comfortable. All right, I will turn this over to Anthony Henderson, who will talk about the grievance policies that need to be in place.
You're muted, Anthony.
Thank you. I couldn't unmute myself. Sorry about that, everyone. So I am going to follow up. Good morning, first of all. I'm going to follow up with Colin's presentation and focus specifically on grievances. So let me share my screen. Sorry, everyone. Give me 1 second. Something weird is happening with my screen share. Let me try it again. Hmm. All right, I'm going to give this a try. I'm not sure if it will not allow me to do my slideshow, so you may have to see the extra slides on the side. I'm okay with that if you guys are. I just want to make sure I can thumb through the slides. Oh, here we go. Now I can do it. Perfect. All right. Thank you, everybody. So I'm going to focus on COC grievances this morning. In short, all agencies should have program rights, rules, responsibilities, and procedures, which include grievance procedures. Participants at intake should be aware of and acknowledge receipt of these procedures before assistance begins. And you also want to cover in that process how clients can submit grievances. The client should acknowledge, or the participant should acknowledge having received it, and a copy should be placed in the participant's file. When clients request, staff should assist clients with submitting grievances, even if it's your own internal process. So you want to make sure that clients get the assistance they need in following the process to be able to file a complaint and to seek resolution for it. In most cases, it would be very, very helpful for agencies to designate a staff member with professional training and conflict resolution, and then possibly a team that reviews and investigates the grievances, and to communicate findings and resolution with participants. And much of what Colin said about documentation will be key in putting things in writing. You want to give participants the opportunity to appeal a decision that they are not satisfied with, and that should be at a supervisory level. So in other words, if a client has filed a grievance and a decision was reached that is not in the client's favor, or the client does not perceive the result to be in their favor, they should be able to appeal with different folks than made the original decision. So that would usually go to a supervisory level. If again, at that level, a decision is not reached that the client is satisfied with, then they will have the opportunity to file a grievance with the COC lead agency. And if they need support and request help to do that, the agency staff should provide that assistance. They're required to provide that assistance. All right, so what goes into a grievance policy? First of all, we want to make sure that your overall policies and procedures include information on grievances, and the grievance policy and procedures in particular should be part of your agency's overall policies and procedures. You want to make sure that the language is clear and fair. You want to explain the program rights, rules, policies, and procedures. Also, the client responsibilities and any violations that would lead to termination. So this is what the client is acknowledging right at intake. They're acknowledging that they understand all of the rights and rules, policies and procedures, the responsibilities that they have, and then what could lead to their termination. And all of this happens before assistance is provided. Due process is a really big component in a grievance process. And what this means is that clients have been provided all of this information right up front. And when a decision to terminate a client's assistance has been made, written notice should clearly explain why. Again, the appeals process may be encountered if the client is not satisfied with the decision. And then, of course, provide prompt written notice of whatever that final decision is. And what's really big is to make sure you have a policy and that you honor your policy. So if your prompt written notice of final decisions says you should do that within 3 days or 5 days or whatever your time frame is, just make sure you follow all of your own policies. Also, include a reference in your policy to the COC grievance policy, which means, basically saying to the participant, if you are not satisfied and if you've gone through our appeals process, you can continue to advance the issue with the COC lead agency. Okay, so here is where this is a live link. So when you receive a copy of this training, you'll be able to click on this. It takes you to the City of Durham website. I realize the picture is very small. It's just a visual to show you what page it's on and where it's located, which is highlighted. So if you're on our Durham COC page and there's a tab for policies, procedures, and standards, if you click that page and scroll to the bottom where you see other policies, I've highlighted where you can find the COC's complaint and grievance policy, which, if by any chance, highly unlikely that your organization doesn't have one, this policy will provide you great guidance to draft one because you are required to have one. Our policy, the COC policy at this link, will be updated upon HSAC approval by the end of this calendar year, but the updated version will replace the existing version. So this same link will work for both today's policy as well as any updates to the policy over the coming couple of months. And finally, also the grievance form for the Durham COC is located on our site as well. Here is a brief picture. We use a smart sheet, and and clients can file grievances through this smart sheet, or they can be assisted in filing grievances through this smart sheet. That's the end of my slide, so I'm going to stop my share. Now I can see the chat, and I want to see if there are any questions. So Princess says that they're a small organization, only 5 of them. It will be difficult to have the appropriate levels of support. Princess, if you have, and Colin, you may want to weigh in on this. I have seen, advisory committees that support the organization, or maybe a committee of the board that takes this on. So there are some options for you, Princess. But you want to make sure that, someone is involved who has conflict mediation experience in the process. And then you just want to make sure that you can provide a fair process. So even if it's a committee of 2 or 3, you can have someone maybe from your board or from an advisory group to assist. And if you need any more brainstorming about that, we'd be happy to jump in and help you think through it.
You're absolutely right, Anthony, using the board as a second tier of appeal or grievance hearing. And if the executive director, to the greatest extent possible, can allow the program manager to make those decisions, then the executive director is able to be insulated and be that neutral person at the end to do it. But at the end of the day, with most nonprofits, the last step of a grievance policy, ultimately, if the executive director is the top of the organization, there usually is an appeal that could go to the board of directors, especially if any of those grievances are related to the executive director. So it's important to make sure that the board of directors is tied into those grievance policies as well as a final stopgap.
Okay, Rebecca has posed a question. If a client is requesting assistance in filing a grievance against another COC agency, is it best to use the COC grievance smart sheet or direct them to the agency directly? Colin, again, everybody, I'm going to refer to Colin because I'm pretty new, but I would guess that they should be referred to that COC's grievance policy and process.
There's two ways that this could happen, Rebecca. If there's a grievance against another COC, the first question is, has the person followed that agency's grievance policy? If the answer is no, then recommend that you start there. Always start with the organization where the grievance is. If the client states, I don't feel safe, I can't do this, or I missed the window to file the grievance, then they can file with the COC. The COC is meant to be the last resort, not the first place to start a grievance, because the first thing we're going to do is say, did you talk to the agency? If the answer is no, it's going to be really trying to get them to work things out at the agency level. The COC grievance is really only when they feel that they've truly been unheard or really unfairly treated. That's when the COC is supposed to step in and sort of be that final check and look at it from a really neutral way.
It also helps to point out, I think I misread the question at first, Rebecca, I got it now though. It also helps to point out when referring a client back to the agency's grievance process, that typically the person receiving the grievance at the agency is not the person that maybe has made the decision, right? So the client or the participant may have said they don't have trust in the process, and so they just want to go directly to the COC. But in reality, they haven't given it a chance because they don't believe that it could be to their benefit, but most times it can. because in some of the agencies, there's different people reviewing it and being, sort of impartial about it. So, it's helpful to direct people back to the agency unless, like Colin said, there's something egregious and they just refuse to do that. But, in many cases, we will look at it and may direct them back to, depending on what the situation is. So, is there a way to know, this is from Rebecca, is there a way to know who the best person in each agency is to contact in case of this? We run into this so often. I would tend to think that you would want to call somebody in, operations or in HR and ask, who is the best person that's dealing with grievances in the organization. We don't have any sort of list for all the organizations that has contact folks for it. And thankfully, I can say in looking at the list of grievances this year, so far, we've had maybe 11 since January, and they vary. There's no particular organization where all of them were filed against. So and they all tend to relate to some type of termination of assistance. So I would just contact the agency to see who in their agency deals with it. And it really should be as friendly of a process as it can be between the organizations, right? So you shouldn't treat the grievance process as a negative, because it really gives agencies a chance to understand what's happening in their environment or the perception that participants have about their environment. So it's really a process to be engaged more than avoided, if that helps. Any other questions about grievances? Just know that we're always here to assist and we will do our best to do that. And I thank you for your time and wish you a wonderful, wonderful day.
Thank you, Anthony. This brings us to the end of today's training. We've got about 19 minutes left in the scheduled training. So if there are any last minute questions, we are happy to listen and answer. If there are no other questions, we can go ahead and adjourn. So I'll give it 2 minutes for anybody to drop questions if you need to. Otherwise, we'll close out. While people are thinking if they've got questions, I do want to say thank you for everyone coming and being part of this, as hopefully it's helping you and hopefully it'll help your organizations to ensure that you don't have findings or compliance issues, and clients will have a better experience and staff will have a better experience as everybody has a clearer understanding of what is and what are all these different regulations that we need to follow. And as Anthony said, we're at community development, we're here to help. And if you've got specific questions, feel free to reach out to us and we'll work with you on technical assistance to help point you in the right direction to solve one-off situations that didn't get covered today, or help clarify specific issues to the best we can.
Well, I just want to take a moment to come back to Rebecca's question about the income, SSI income of disabled children under 18 as part of annual income reevaluations. And I found some guidance on the HUD website, posted it in the chat. It suggests that SSI income of a disabled child is considered part of a household income. employment income is not. Thanks.
Recordings will get posted on the website, and the PowerPoints will be posted on the website or mailed out or emailed out as well. So thank you for everyone's attendance today. And if you work with any of your colleagues who were not able to make it today, they are more than welcome to watch the trainings and complete the surveys, questionnaires, quizzes for credit for getting this done. And we'll see you all tomorrow morning to go over all of the new forms that will go live January 1st. With that, have a wonderful afternoon, be safe, and keep up the great work for helping those in the community experiencing homelessness. Take care.